Welcome. So the big news this week in mid-September 24 is, of course, the Apple state aid case where the European Court of Justice decided that Apple owed Ireland 13 billion euros in taxes. So let's have a quick look at what happened here. So a very quick summary of what was going on here. You had Apple Inc. at the top, and you had a subsidiary, a holding company underneath. We'll reference AOI. All the full case, company names are in the decision itself, and it held two subsidiaries incorporated in Ireland, AOE and ASI, Apple Sales International, and the other one was, I believe, Export, which had former names of ACL and ACAL. These companies were incorporated in Ireland, but they were not resident in Ireland. So there was Irish non-doms, but they did have branches in Ireland. And the companies themselves in the head office states, I can't remember if that was Bermuda, had no employees, but they had quite a large number of employees in Ireland. And so what happened was Apple made tax rulings with the Irish tax authorities in 1999 and in 2007, in which they agreed on what the taxable basis for these companies would be. And part as the companies were used as a part of a US structure to shelter at the time US sales, the profit on US sales from US taxation. And this happened, it was quite a common Irish-Dutch sandwich where they were called in many cases, sometimes they involved Switzerland. But you basically had the branches in Ireland doing all the work. You had the companies being non-domiciled somewhere in a tax haven, and then you would make payments through a Dutch company or something that didn't levy withholding taxes on royalties, for instance. And quite a lot of work was done by the branches because for US purposes, you entered into a cost contribution agreement whereby the Irish companies would contribute to all the development costs of Apple, to R&D and everything else. In exchange for that, got the sales right of all Apple products outside of the Americas as part of its compensation, and then sheltered all the profits from that in Bermuda. And the European Union attacked the structure, saying that these rulings that Apple got constituted state aid, illegal state aid, because it put Apple at a competitive advantage compared to other taxpayers in Ireland and therefore also in Europe. If we just move the structure aside, this is what the General Court decided in 2020. It said in these cases, T77-816 and 892-16, insofar as it's been established that the strategic decisions were taken in Cupertino, which is in the US, Apple Inc., on behalf of the Apple Group as a whole, the Commission erred when it concluded that the Apple Group's IP was necessarily managed by the Irish branches of ASI and AOE, right? So what happened here, I see I have got the name spelled wrongly, but what happened here was that the Commission said that the profit belonged to the Irish companies because they had this license agreement and they had this cost contribution agreement type of arrangement with the US, whereby they could keep the proceeds from the sales of the non-American sales, and that those profits should be taxable in the branches because the head offices were not doing anything, all the functions, assets, and risk were performed by the branches. And Apple and Ireland and argued, no, that is not the way it works because the real decisions were made by Apple Inc. and therefore the profit should go to Apple Inc. And part of the Commission's problem with the decision was that was not how transfer pricing works. It's a logical way of thinking because one could argue that the agreement between Apple Inc. and the Irish companies was not at arm's length, but that was not the case that was litigated here. The case that was litigated was that the allocation of profits between the branches and the head offices were not correct. And part of the Commission's argument in this appeal was, once you've signed that contract saying you can keep the profits for the non-American sales, a third party wouldn't just give that up because all the decisions are now all of a sudden made by Apple Inc. in the US. You've got a contractual right to those profits, and a third party would have claimed that right. And this was part of the grounds of appeal as well. And then just to wrap it up, the court concluded in paragraph 310, it is apparent from the foregoing considerations that the Commissioner has not succeeded in showing that in light, first, of the activities and functions actually performed by the Irish branch of ASI and AOE, and second, of the strategic decisions taken and implemented outside of those branches, that Apple Group's IP licenses should have been allocated to those Irish branches. Before we look at the TP decisions in this case in detail, let's just do a quick overview of the case at a very high level. So there were two primary arguments made by the Commission. The first one is that the General Court has erred in its reasoning about the Commission's decision, saying, you didn't really understand what we decided. And the second argument was countering a whole bunch of formalistic arguments by Ireland and the taxpayer, that the Commission somehow made some kind of formal mistake, and therefore this was not illegal state aid, and therefore they still don't have to pay, right? But if we look in detail a little bit more at the first decision, the first argument that the Commission made was the Commission did not rely on an exclusion approach. And we look at this in a little more detail. But so what the Commission says is we didn't only look at the fact that the head office had no people and therefore concluded all the profits must go to the branch. That's not how our paper was made up. And so they say there are a number of issues here. First of all, the court misinterpreted the Commission's decision in the sense that Section 25 of the TCA, the Irish Act, does in effect require the arm's length principle to be applied, and it does actually require the AOA, the authorized OECD approach to the allocation of profits to PEs, to be applied. Maybe not the exact documents, but the same methods in substance, right? And that is also what the Commission used, and they didn't apply any other norm, as a lot of people have been saying. Second, the Commission says we have compared the HQ's profits to the PE's profits and came to the conclusion that there was a mismatch. We didn't just conclude that because the HQs had no people, therefore the PEs had to have all the profits. Thirdly, it said, remember that the Irish companies had a license agreement with Apple Inc. And according to the license agreement, it was entitled to certain profits. And by saying, well, actually, those profits did not belong to the Irish companies, and the discussion is not about whether it should go to the Irish branches or to the foreign head offices of these Irish companies, but that should go to Apple Inc. The General Court has made a error. And finally, the Commission said, these tax rulings that we talked about did give a significant advantage to Apple compared to other taxpayers doing similar transactions but not having these rulings. And the court agreed with Apple, with the Commission on that, and therefore arguments 2 and 3 in this first complaint with the Commission was not necessary. And remember, the first complaint was that the court made an error in its judgment on the matter in substance. The first one was the Commission did not apply exclusion approach. The second one again was that the court could not include Apple Inc. And the Court of Justice of the EU agree. First of all, Ireland and Apple tried to argue, but that's not what the General Court said at all. And as we saw when I showed you the original decision of the General Court in the beginning of the slide of this video, it is exactly what the General Court has said, right? And then Ireland and Apple tried to also argue, but I mean, even if that is true, that's not significant for the case. And the Court of Justice said it's been very significant for the case, but because of this reason, the General Court has decided that the Commission had erred and this was not state aid. And then the final group of arguments of the Commission in this airing of the reasoning of the General Court was regarding the activities of the Irish branches and their PEs. And first of all, the evidence given that there were some activities primarily through powers of attorneys and stuff like that, not through real people work, that could be allocated to the head offices was inadmissible because it was brought in halfway through the procedure. It wasn't brought in when the Commission was doing its investigation, and the Commission only need to pay attention to data that's given to it during its investigation. And secondly, the General Court asked the Commission to prove a negative, and you will see a little more detail about that hereafter. I'm not going to discuss the second part in detail, but I will give you the highlights of it. And the second part was whether there was state aid, right? So this is much more EU law-driven thing. And the first question was whether these rulings were selective in nature. And the answer pretty much is yes, they were, because they were only for Apple. They will not apply in general. The second one was whether there was an intervention through state resources. Did Ireland give the advantage to Apple by missing taxable income? And the answer to that is yes, that would be one way in using state resources to give a group a advantage. And then the third one was that Apple and Ireland complained that the the initial draft framework given by the commission of we think this is state aid, these are the issues that we're looking at, were not complete, were not exactly the same as the final decision, and therefore their right to be heard was infringed because they couldn't answer things which only came up in a final decision that wasn't put in a framework. And I mean, if you think about a normal tax audit, they would ask questions, and based on the answers that you give, they would come to a conclusion. So the questions that they ask or their initial arguments may not always be exactly the same as where they end up in the final assessment, and that's effectively what happened here. And the Court of Justice says, the opening decision defined the framework, and that was clear enough as in what goes on, etc., etc. And then there was also comments, yeah, but the commission was biased because staff from the commission have already said that we're guilty, and so the commission it was not a fair trial, basically. And I've been to some of these meetings when this happened, and the individual who was leading the investigation from Germany at the time, he was publicly attacked, I think very often pretty viciously, for doing this case, for his arguments, for his documents. He was just leading the team running the state aid investigation. He was feisty. He always fought back. But the Court of Justice says, he was giving his personal opinions. He was not the commission, right? So what he said was not what the commission said. He was talking in I take it, a personal capacity. And then if the applicants thought that they should say something, they should have. They shouldn't wait until they're asked for something specific before they say something that they think can help them. They simply need to respond to it accordingly. And then Ireland and Apple also said, yeah, but this was against their legal certainty and legitimate expectations. And the arguments that they used were, the commission only came with this in 2013. The rulings were in place since 1999, and the commission just said, we've never been notified about these rulings. How should we have known? We were notified in 2013, and we started the case in 2013. And under EU law, when you get a ruling from a government, you can't, when it comes to state aid, say, oh, but we thought this was legal because we got it from the government. EU law very clearly says, if you want to know whether this ruling is legal or not, you've got to ask the Commission. Apple never did that, so it could not rely on this train of thought because Apple has enough money to afford expensive lawyers who could have told them, right? Then they also said, yeah, but this was a completely new case. I mean, this has never happened before. And the Court of Justice says that's not true. I mean, the Commission has had many tax cases on state aid in the past. And you could have known about this. There have been earlier cases. The Commission tried under Commissioner Monti as early as 2007 to run these things, but there are some agriculture cases and port cases and airline cases also dealing with taxes much older than that. And if you are informed about EU law and state aid rules, you would have known about this. Furthermore, it was also just a point in fact that Apple has never asked for compliance with the state aid rules, so it took the risk by not asking. They then tried to argue, yeah, but the Commission applied the AOA, which is a document that was only published in 2008, and therefore they gave a retroactive effect to the AOA, and that's not fair because the rulings are from 1999. And the court says, the only thing the Commission applied was the state aid rules under the Treaty of the Functioning of the EU. Those rules are much older than the AOA, so there is no retroactive effect. And then the taxpayer in Ireland also, or at least one of them, tried to argue that the Irish rules that were under the TCA 1997 have been in the Irish law for decades, even before Ireland joined the EU, and therefore those rules were grandfathered under the Irish accession to the EU, and you can't now say that those rules are wrong. And the Commission argued, and the court followed it, the Court of Justice, saying, we're not attacking the Irish law, we are attacking the rulings that you got in 1999 and in 2007, and those are not grandfathered. So let's look at the case itself in more specific detail. So let us look and see what the Court of Justice said about the Commission's appeal. One of the things that the Commission said was that it did not rely on an exclusionary approach. The General Court said the Commission argued that since there was no one in the head office, all the profits must be allocated to the branches, and that is not how transfer pricing works. And the Commission said, you don't understand our decision, that's not what we said. And the court then looks at this and notice the following. It says, it follows that the Commission first of all found that it was appropriate to compare the functions performed respectively by the head office and the Irish branches in relation to the IP licenses. So the Commission didn't just jump to the conclusion that if the HQs did nothing, then the branches must have done everything. Next, in applying that test, it carried out a separate examination of the role assumed by each of those head office and each of those branches. Following that examination, it found an absence of functions in relation to the IP licenses in the case of the head office and an active role by the Irish branches resulting from the assumption of a series of functions and risks associated with the management of those licenses. And that's where the profits came from. Thus, the Commission's primary line of reasoning is based not only on the lack of functions performed by the head office, but also on the analysis functions actually performed by the branches in related to those functions, to those licenses. Therefore, as the Advocate General noted, it was not the finding that the head offices had neither employees nor physical presence outside of the Irish branches that led the Commission to conclude that the IP licenses and related profits had to be allocated to those branches. The Commission drew that conclusion after linking two separate findings. First, the absence of active or critical functions performed and risks assumed by the head offices, and secondly, the multiplicity and centrality of the functions performed and the risks assumed by those branches. So the Commission did not apply an exclusionary approach. The next argument of the Commission was that the General Court should not have looked at Apple Inc. because this was a case about the profit allocation between the branches and the head offices and not about whether the profit allocation on the contract was between Apple Inc. and the Apple companies were at arm's length. And the text says the Commission submits that the legal test applicable under Irish law for the purposes of determining the profits of a non-resident company that are chargeable in Ireland was correctly identified by the General Court in Article 248, and that test must take into account the allocation of assets, functions, and risks between the branch and the other parts of the company. So it is general transfer pricing here, right? Part of the question was also all along whether Irish transfer pricing rules were different from OECD transfer pricing rules and whether Ireland had the obligation to apply the OECD transfer pricing rules. And what you read between the lines of the court decision is that, generally in Europe, countries must treat companies at arm's length as some implicit condition of state aid. At least that's what I read between the lines. Ireland, however, submits that the relevant analysis must cover actual activities and the market value of those activities. For their part, ASI and AOI submit that because both the Irish government and the companies appealed the Commission's decisions, and ASI and AOI submit that under Irish law, the profits derived from the IP can be attributed to the Irish branch only if the IP that generates them is controlled by the branch. And what they said was, since the contract was signed by the management of the companies which were not in Ireland, it must have belonged to the head office and couldn't have been allocated to the branch, even if technically there were no functions performed by the head offices. And the Court of Justice then concludes, it follows from the judgment under appeal that the General Court's assessment that the Commission erred in finding that the branches of ASI and AOE perform significant people functions in relation to the Apple Group's IP is based largely on an examination of the functions performed at the level of Apple Inc., which the court itself considered not to be relevant in the present case, right? The Commission's argument that the functions performed by Apple Inc. were erroneously taken into account is therefore well-founded. It follows that the second complaint in the second part of the first ground of appeal must also be upheld. So the Commission also won this argument. And then we come to an infringement of Article 107, and here it was a question of that Ireland and Apple accused the Commission of not using certain information or saying that certain information disproved what the Commission was saying with regard to the lack of functions by the head offices. And the Commission says, under Article 107 of the Treaty of the Functioning of the EU that deals with state aid, we only need to consider the information that you have given us during the administrative procedure while we were making the document saying that we suspect, say, state aid, right? And you haven't given it to us at that time. And so the court says in that regard, it is apparent from well-established case law that the lawfulness of a decision concerning state aid falls to be assessed by the EU adjudicator in the light of the information available to the Commission on the date when the decision was adopted. So the Commission lets the country and the interest party knows, hey, we think there's state aid going on here. These are the things that we are considering. They give a framework, right? Please tell us why you think we are wrong. And then after they've been some back and forth on discussions, et cetera, the Commission then come to a final decision saying, okay, we agree this is not state aid, we're done. Or they think, no, this is state aid, and you need to collect back the money, right? And it's almost like doing a tax assessment during an audit. And then the court says in paragraph 186, it was incumbent on ASI and AOE to submit that evidence that was submitted later to the Commission during the administrative procedure. You can't do it afterwards and then complain that the Commission didn't apply it, right? Lastly, it must be noted that contrary to ASI and AOE's contention, the Commission's complaint is not ineffective. It was by relying on the evidence referred to in Article 301 of the judgment on appeal that the General Court found that the Commission had erred when it concluded that Apple Group's IP was necessarily managed by the Irish branches of ASI and AOE, which held the licenses for that IP. And there was a bunch of power of attorneys and stuff like that involved here, which was supposed to allocate those functions back to the head office. And the court just says, if you thought that was so important, why didn't you tell the Commission while they were busy with the investigation? Why do you wait until you litigate and then come up with the stuff that you have found by accident, right? So then there was last thing that the Commission argued, and the Commission said, one of the court's conditions that they said to us, they asked us to prove something which we could not have done, right? So they asked us to prove a negative. In the second place, the Commission considers that the General Court imposed on it a burden of proof which was impossible to discharge, and it had links to these powers of attorney that I mentioned, right? And then Article 245, the court quotes the Advocate General that says, as the Advocate General stated, the reasoning set out in paragraph 304 of the judgment of the General Court would preclude the Commission from being able to rely on the fact that the company's board minutes do not mention certain categories of decision to support his assessment that those decisions do not exist. However, such reasoning does in fact impose an excessive burden of proof on the Commission, because the argument I think, but I don't know, goes something along the lines of, yeah, but you read those documents and it didn't say that we did these things, but that doesn't mean that there were other documents that might have said that we did these things, and you should have asked for it, right? And the court really turns that around and say, if you think it's so important, you as a taxpayer or you as a government can also tell the Commission those things because you believe they are important, right? And then we come to the final decision of the court about the first category, the real TP issues of the case. The court summarized what we just looked at. It said the first ground of appeal must be upheld, and this is why the Commission won. So the Commission won the transfer pricing part of the case. First, the General Court erred in law by finding that the Commission had adopted an exclusion approach. Consequently, it erred when it held that the Commission's primary line of reasoning was based on an erroneous assessment of normal taxation under Irish tax law applicable in the present case. The General Court also committed a breach of procedure by taking inadmissible evidence into account in support of its assessment, what we just looked at. Secondly, by focusing on the functions and risks assumed by Apple Inc. in relation to IP, instead of concentrating solely on the functions performed by the Irish branches and by head offices, the General Court proceeded to characterize the facts, applying a different legal test from that which the court had itself considered applicable under Section 25 of the TCA, that's the Tax Act of 1997. That reference framework requires account to be taken of the allocation of assets, functions, and risks between the branch and other parts of the non-resident entity, and precludes the roles of separate entities, such as a parent entity, in this particular case, Apple Inc. Thirdly, the General Court imposed an excessive burden of proof on the Commission by finding that the fact that the minutes examined by the Commission do not give details of decisions concerning the management of Apple Group's IP licenses does not mean that those decisions were not taken, and we've looked at this before. So the General Court erred when it ruled that the Commission's primary line of reasoning was based on erroneous assessments of normal taxation under Irish tax law applicable. I hope you enjoyed the case. I'm not going to look in detail into the more EU-based arguments that we've discussed at the beginning of this video, but I think it's quite a surprise. When I read the General Court's decision in first instance, I agreed with the General Court because it made sense that all the value-added work was done by Apple Inc. But now reading the Court of Justice of the EU's decision reversing the Commission's decision, the General Court's decision, I must say I understand where they come from, right? The case here was about the profit allocation between the branches and the head office, and the Commissioner is right. If you've signed an agreement that allocate profits to you, as between the Irish companies and Apple Inc., then you don't need to go and look when you do the profit allocation between the branches and the head offices whether that arrangement is at arm's length. In the sense that if third parties signed an agreement like that, they would insist on getting those profits. You can't afterwards say, "Oh yeah, but you signed the agreement, but we're going to ignore it because actually we think that the profit should go to Apple Inc." I look forward to discussing another case with you next time, and I hope you enjoyed this one. Bye for now.